It's December 2013. I thought it'd be relevant to put down a few thoughts on restraints of trade, a very common problem that companies have when it comes to dealing with people who've left, and employees have when it comes to having left a workplace, is restraint of trade, and that is a prohibition on you approaching clients, dealing with clients, working in the industry and so on for a specific period. As a matter of common law, so long as we're not doing something strictly illegal, then the idea of a democratic society is that you can do whatever you like. You are allowed to work in your chosen field of endeavour unrestricted, and the purpose of the legal system is primarily to make it easier for you to do that. However, there is a balance, and that's what a legitimate restraint of trade is, a balance. That's a reasonable restraint of trade, as it's called. That is, while you are doing what is acceptable and proper on your behalf, you should not do anything that harms another person because of their vulnerability arising from your knowledge of their trade or profession. Now, just imagine if you're a sales rep and you sell goods to a particular line of wholesalers. Well, if you immediately leave and then start selling goods on behalf of a competitor of your former employer to exactly the same chain of wholesalers, then it's very obvious that you could be doing damage because of your particular knowledge to that former employer. So therefore, the former employer can reasonably restrain you. That's just a very obvious example. I have seen another extreme where a person was required to sign a restraint of trade whereby they would not work as a truck driver anywhere in the world for 2 years after they left. Well, that's just nonsensical. That person wanted to work as a truck driver and could not, and according to this restraint of trade, could not. Now, in all states except New South Wales, if a restraint of trade is held by in the equity jurisdiction of the Supreme Court, is held to be unreasonable, then it falls. It does not stand at all. In New South Wales, we have the Restraints of Trade Act, whereby the Supreme Court can read it down. So I've got one in front of me here that it says, the executive must not, for a period of 6 months after the cessation of his employment, either directly or indirectly, approach, solicit, interfere with, or endeavour to entice away any employee of the employer, or the same again for any client, customer, or supplier of the employer. Now, the Supreme Court in New South Wales can assess whether or not, in the circumstances of this particular case, and my advice to this client is that they will do this, can read down the 6 months to 3 months, say, or 4 months, but it can read it down from 6 months. In other jurisdictions, if the particular facts of the matter led the court to find that it was an unreasonable restraint of trade, it would set it aside. That's why we have a thing called a cascading restraints of trade that are very, very common. That is, it's 12 months, if not 12 months, then 9 months, if not 9 months, then 6 months, then 3 months, and so on. And if not all of Australia, then all of Victoria. If not all of Victoria, then 150 kilometres from the Melbourne cricket ground, and so on. Now, those work. It has been suggested that that's an indefinite set of restrictions. Like, what does that mean? Well, there's a case called OAMPS, O-A-M-P-S, from 2010 that says that so long as you can definitely assess each one of those obligations, that is 6 months, 150 kilometres from the Melbourne cricket ground, or 200 kilometres from Melbourne, or the state of Victoria, and 9 months, so long as you can assess all of those and look at whether or not they're reasonable, then it's not void for uncertainty, as is said. So the point to make is that, unlike what a lot of people will say, a restraint of trade in a contract is enforceable. A restraint of trade is enforceable, but however, only if it is reasonable. So it's important when drafting contracts, or when enforcing contracts, or when requiring a former employee to abide by them, or if you are a former employee, when you receive a warning letter from your employer that you must abide by them, is to test that word reasonable in the circumstances of that matter. Is this restraint of trade reasonable? If you are a truck driver and you work for a particular company, yes, indeed, you can work as a truck driver anywhere in the world as long as you like, so long as you're not stealing clients from your employer. Such a restraint of trade would be nonsense, so it would be set aside. On the other hand, if you're a sales rep, you have access to a set of wholesalers, you're selling one product, then you can be restrained for, say, 3 months from selling a rival product to that set of employers. Reasonable restraints of trade. Do not ignore them, but do not let them be exaggerated up to the stage where it is believed that an unreasonable restraint of trade would be enforced. Hope that was useful.